Good evening. This is Laws 12062 Alternative Dispute Resolution. We're into week 10 and we're dealing with other ethical and registration issues to do with the ADR process. The commentary tonight is based on Chapter 7 of Spencer's book, Principles of Dispute Resolution, as usual. And that covers pages 203 through to 220. So I'll provide some commentary, but also ask a lot of questions which are troubling me in relation to this issue. I should confess that to some degree I'm a little old school in relation to what is a very new topic. So ADR has really only been around as a topic for about 40 years or so. During the early 1990s, I undertook a number of courses in ADR, sensing that things were about to change. And as a result of that, I became accredited to the degree that one could become accredited in the 1990s. And during the 90s, I conducted literally hundreds of mediations. At that stage, we weren't involving ourselves in conciliation and hybrid hearings, but just mediations. The classical model, which was really the non-interventionalist model, and also the more directive model through different agencies such as the Dispute Resolution Centre, Legal Aid, the Queensland Building Tribunal, as it was now. It's now QCAT, the Office of the Mediation Advisor, and a number of other bodies. At the turn of the century, I changed focus in my practice, and primarily I was in court as an advocate almost every day. So I didn't practice in mediation for a period of time. And what happened is that the grandfathering provisions, which I could have taken advantage of in relation to the new registration models, came and went. And I've now had to redo from scratch the training, which has been very time-consuming, worthwhile, but very time-consuming. The concern that I've got is that many people who are, I think, naturally going to be very good at mediations are going to be hesitant about undertaking the extensive amount of training that needs to be undertaken to be accredited, and then the ongoing CPD requirements, that's the professional development requirements, to be a mediator. And I am concerned that many good people that undertake mediation work will be lost to this newly created profession as a result. So I have a number of questions in relation to it, and I sense that Mr. Spencer has concerns about certain issues relating to the accreditation and registration process, and I'll come to those shortly. But firstly, some comments in relation to ethical standards. ADR was originally created, if you like, as an adjunct to work that was being done by professionals such as lawyers and psychologists. So I came to it via the law. The regime of having specialist and particularly accredited mediators is relatively new, certainly to the extent to which one needs to be considered the training that's needed for accredited mediators these days. In the 1990s, there were training bodies. I went through Legal Aid Queensland. I went through the Institute of Arbitrators and Conciliators, I think that is the body, through the Alternative Dispute Resolution Centre. So I went through a number of different training bodies, but I received my certificate, and that was essentially all that needed to happen. We didn't have a governing body back at that stage. So the question in my mind is, do we need to have a governing body? To what extent should the governing body regulate this newly created profession? To what extent do consumer laws, torts laws such as negligence, and contract laws generally apply to dispute resolution practitioners? I think the answer is they do continue to apply. Do we need to have a separate code of conduct for ADR practitioners, given that many practitioners who in their field are lawyers, engineers, psychologists, social workers, and they're all governed by their own code of conduct and ethical requirements. So do we need to have specialist ethical standards and codes of conduct that apply to ADR practitioners? Do we need to have different codes of conduct or ethical standards that apply to ADR practitioners who act as facilitators as opposed to those ADR practitioners who act in a more determinative fashion, such as arbitrators? What are the professional indemnity insurance consequences of developing a separate profession? Are we driving away lawyers who would otherwise be comfortable and proficient in undertaking ADR work and replacing qualified people with arguably less qualified communicators? And given that, in my view, ADR is very much about communication, which is why I've urged you to communicate with your assessment pieces through Zoom sessions, it does seem a waste for some of the best communicators to be driven out because of compliance issues. Are we creating a multitude of different registration and ethical guidelines for mediators? For example, the nationally accredited mediator is not necessarily going to be a family dispute resolution practitioner because there are different requirements. So I have some concerns, and I apologise that I've raised many more questions that I've provided answers. I'm yet to be satisfied that the process which is currently in place is truly going to be a satisfactory and largely appropriate regime for ADR practitioners. I hasten to say that is purely my personal opinion in relation to the regime. And having said that, I come from the background that I explained, which means that to some degree my opinion is coloured by my own experience. I have, of course, made my comments based on an assumption, and that is that ADR is a profession. So the question into my mind then is that really the case? Is ADR now a profession? And there are some issues that revolve around that. I mentioned indemnity insurance policies. If one is truly going to have a distinct and separate profession, one would expect indemnity insurance policies would apply in relation to those professional obligations. Should ADR practitioners have indemnity insurance? Many of them are covered by their own indemnity insurance policies, such as lawyers. If ADR is a profession, we need to go back to the original definition of what is ADR. And you'll recall that we have that continuum, which is quite wide-ranging, where on the one hand, at the most informal level, we have negotiation. And at the most formal end, we have arbitration. So is an arbitrator really an ADR practitioner in the usual sense of the word? Is a person who is a professional who happens to be involved in negotiation truly an ADR professional? So if negotiation is a form of ADR, does that mean that all professional people, and I'm highlighting professional people in the context of ADR being a profession, are they people that should be considered by the same ethical standards as ADR professionals as such? So a lawyer, for example, will very commonly involve him or herself in negotiations. It's what we do. If that lawyer is not an accredited ADR professional, is there some issue with that lawyer conducting negotiation if we accept that negotiation is a form of ADR? Once again, I apologise for all my questions rather than answers. All right, let's talk about documenting ethical standards. Why do we need to document ethical standards? Well, I guess if we go back to basic principles, a profession is, of its very nature, an organisation which is self-regulating. That largely has been eroded as a result of the intrusion, a little bias there, introduction of consumer laws that might affect the operation of a profession. Looking at law, for example, when I first started in the early 80s, we were largely self-regulated. But since that time, we've had the introduction of the Legal Services Commission, which is, if you like, a co-regulatory body in relation to the practice of lawyers and works in conjunction with and supplements the Queensland Law Society. So there have been these intrusions into, by external means, into what might otherwise have been the self-regulation of the industry, which is essentially what is a profession. So what do we need to document if we're going to talk about documenting ethical standards? And why would we need to do it? I guess one reason is to provide quality benchmarks. So if it's appropriate to consider ADR practitioners as professionals subject to ethical standards, then we document the ethical standards so that we can judge the practitioners against those standards. That makes sense in theory, but as Spencer quite rightly points out, given the confidential nature of ADR practice, it's very hard to enforce that. Maybe the reason for documenting ethical standards is to satisfy consumer demand. Maybe it makes the consumer feel more satisfied that they're dealing truly with a professional if that professional is subject to distinct ethical standards. Maybe it inspires public confidence, in other words. Maybe the documenting of ethical standards will assist in the accreditation and registration process that I have some concerns about. And maybe the ethical standards being documented provide some comparative statement in relation to disciplinary hearings and comes back to that issue of the benchmark. Mediator Standards. The Law Council of Australia has some guidelines in relation to process. You can read about that in Spencer's book. And the process, particularly in relation to mediation, follows the process we've followed throughout this course. So number one is the obligation to impose or provide rather information about the process to help the parties identify their real concerns and options, to ensure the parties are informed and deal with instances where there has been fraud or misleading statements. So the Law Council of Australia, in the context of mediator standards, says that that's the first obligation for a mediator, to provide information about the process. The second guideline from the Law Council of Australia's perspective in terms of regulating the quality of mediators is to do with impartiality. That is, to avoid the appearance of partiality or prejudice, to be conscious of behaviours which might indicate impartiality or prejudice, indicate partiality or prejudice, take care in offering opinions even when requested, and consider withdrawing altogether if the matter is not resolved. So that's what the Law Council of Australia says might be relevant for a prudent or appropriately qualified ADR practitioner in mediation when it comes to impartiality. I guess you could add to that the obligation to advise the party that you're dealing with that you have no previous contact with the parties, or if you have, to make that disclosure. So, comment coming through is that the neutrality of the mediator or facilitator is an important quality or standard, and I agree with that. The next issue, which is identified by the Law Council of Australia, is conflict of interest, and that is to discuss circumstances which may affect independence or impartiality and be transparent about that. Competence, be appropriately trained and accredited. Confidentiality, take care in private sessions. Termination of the agreement, take care with an agreement that appears to be unenforceable or illegal, and take care if it's unlikely that there will be a result of settlement. And recording the settlement, take care in drafting the agreement as it may be construed as you providing legal advice. So there's some of the issues which have been raised by the Law Council of Australia in terms of the practice of a mediator. And I won't argue against those, However, I would say that in the context of how one conducts a mediation, they're fairly obvious and fairly basic. All right, well, I promised you a short session tonight, so I'm getting close to the end. I just would like to refer you to the National Mediator Accreditation System Standards, which you can read for yourself on page 211. And also, when it comes to arbitration, we're resorting to the American model at this stage at least, and on page 220, sorry, I'm just looking for the actual page, the American Arbitration Association Code of Ethics is referred to in the text, and I apologise, I can't find the page just at the moment. Yes, here it is, 209. All right. Other than that, I just wanted to thank you very much for your participation so far, to congratulate those of you who have already put in your Zoom sessions. I'll be marking those this week and get the results back to you. Good luck with your simulated mediation in a practical sense, which is task number 6, and some of you have already completed that task and have sent those videos in to me. Now, unless there's any questions, I propose to wrap it up for tonight. Just looking to see if there's any questions on the screen. All right. That didn't come through, Margaret. Okay. Oh, no questions from me. Thank you. All right. Well, I'll wrap it up for tonight, and all the very best. Bye.